The collapse of the Champlain Tower South raises a host of legal issues, questions about liability, financial responsibility, and compensation for loss.
Homeowners associations are an important part of that equation. We've talked about that. David Haber is one of the leading attorneys in South Florida dealing with construction law, and that involves representing the homeowners associations that make the decisions for those buildings. And he is here with us live. Good morning, David. Good afternoon, sorry. Good afternoon.
Good afternoon, Glenna and Michael. It's nice to see you both, unfortunately, in this tragic circumstance.
So just want to lay, you are not part of this firsthand, this building, any of the Champlain Towers. You are not representing those homeowners associations, which gives us here a level of objectivity we might not ordinarily have.
Right.
That's correct.
David, if I can, let me begin with asking you some legal questions. I mean, the 136 units in that building, I'm sure that each homeowner had some kind of insurance. The HOA has insurance. Who is going to pay the people who lost their homes and their lives in this case? Will the insurance companies try to somehow squirrel out of this?
Well, Michael, you ask a very interesting question. Each person has homeowner insurance for what we call the walls in, the paint, their flooring, but the structure itself is covered by the condominium association insurance, which typically has a value of the value of the building itself and what it might cost to rebuild that building. Mm-hmm. And whether insurance carrier or carriers will try to squirrel out, tongue in cheek, the answer is I've never seen an insurance carrier that doesn't try to find an exclusion or an exception to coverage. However, if and when the lawsuits come, because there may be a tender of the policy limits, the problem here is that there's such a large and tragic loss of people that even if some are recovered alive, there presumably will be many that are not so lucky that the insurance coverage, including the umbrella coverage, would not necessarily provide any solace to family members.
Oh, and as you're speaking, we're actually looking at video of the recovery work going on right now. David, we talked for the last 10 minutes or so with the man you know well, Rick Slider, structural engineer, and he said something toward the end of our segment that homeowners associations don't want we were talking about the really expensive projects of remediation and restoration and repair that were identified in this 2018 report. He said, quote, homeowners association, they don't want to pay for it. And he was talking generally, of course, not about this, clearly. As a homeowner association, the board representing residents, when you see the kinds of warnings, really, that are in this report, how could you not want to find a way to pay for that? What is that like? Take us through that kind of mindset and process.
Sure. The process is an interesting one, but it's also a political one. And we need to understand that board members are elected, and they're elected by owners. And many of these older buildings up and down our coast, and I know that Channel 10 goes up and down the coast. So if you were to go from, let's just say, Coral Gables all the way up to Palm Beach, you will find older concrete buildings, many of which have people with fixed incomes. The idea that in the 39th or 40th year, they're going to get hit with a $25,000, $50,000 assessment is quite a wake-up call, if you will, to people who may not have the means necessary. One of the things that people, and I do know friends of mine who have relatives that were in that building that are still unaccounted for. One of the things they asked me is, David, what can you do to help change the legislation? And I think it starts with the fact that we have reserve accounts, but it's just too easy to waive those reserves especially for structural components. Or you have the right to pool reserves and spend the money on your lobby renovation, because what the lobby looks like is going to get you a higher fair market value rather than what the garage pillars look like and structural support columns. Sooner or later, you have to pay the piper. And if you waive reserves or have insufficient reserves, somebody's going to hand you a bill in year 40 that it's very difficult for a board to say, hey, we need to come up with $8 million. Now, you can get a loan, but the payments are still significant.
I just want to reframe. I'm sorry to interrupt. I want to reframe sort of in layman's English what I think I'm hearing you say is that homeowners associations wait 40 years before putting money into anything structural because they have to?
I would say that some associations either defer reserves, partially fund reserves, or waive reserves. And they can do that year after year after year. Now, the law is that you need a majority of a quorum, and everybody's condominium documents are different. But we've seen condominiums that have as low as 33.33% for a quorum, or even lower. So let me just give you a layman's term on that. If you have 100 unit owners, you need 34 to show up to a special meeting, and you need 18 to vote in favor of waiving reserves. So you can do that year after year after year. And if in years, let's just say 30 to 40, you're waiving reserves, and the bill comes in at $4 or $5 million, that's a lot of money. That's $50,000 per unit.
Right. Well, we do know, David, that the Homeowners Association at Champlain Towers apparently had reached an agreement not to waive reserves, but in fact to assess building owners. They had some kind of a payment amount set up. We don't know how much it was over a 180-month period. I mean, it must have been a large assessment on that building, or else why put it over a 15-year period?
Well, as you heard from Mr. Slider, there was significant damage with the pool deck and the slab, and they needed to rip up the pavers. This is very expensive. I also want to point out, I've had associations that they don't want the pool deck closed during the summertime. There's a lot of politics in condominium associations. You just need to understand these are elected people. I've had associations where if they wanted to pass a big special assessment, they were voted out of office.
Yeah.
The other thing I want to point out is, I think that the 40-year certification process needs to change. For example, it takes time to hire the engineer, have the report done, have the report issued. Then the engineer has to come up with plans and specifications.
Yeah, if I can interrupt you, Rick, let me ask you the question, in fact, that we asked Rick Slider is, for oceanfront buildings which are open to the corrosion of salt air and water, should the recertification period be 25 years or 30 years, not 40 years?
Well, I think you could take it down to 30 years. I don't know about 20 years, but I know this. Between the time of the engineer getting into the building and the time the plans are done and submitted and a contractor is vetted, because you need 3 bids for contractors for a condominium, it can take a year or 2. And then the remediation efforts can take anywhere from 1 to 3 years, because you saw how extensive the remediation needs to be with respect to the pool deck and the columns. So you may be talking about a 4-year process plus minus. So if you're starting in year 39, your 40-year certification may not be finalized until year 43 or 44. And I think that's problematic.
Yeah, and we see from these documents that the permits, at least for the roof that the work was going on, was pulled last month. So David, we want to talk about what we've heard elected officials call for legislative change. So sit tight. We're going to take a couple of minutes of a break, and we'll talk about that when we come back. We are back on this special edition of This Week in South Florida, speaking with attorney David Haber, who does a lot of work in construction and building, and especially with homeowners associations. David, in the last segment, we started talking about these 40-year recertifications, all the work that goes into them. And we started by talking about, is that an appropriate length of time for high-rise buildings facing corrosive environments like salt and water, et cetera? Here's my question to you. The legislative changes that we're hearing elected officials now want to make in light of the collapse and what it will reveal. They are saying there are now at least 3 cities that we know of on the coast will be doing inventory, is the word they're using, of all their older buildings. And my question is, why would an inventory not be redundant if a 40-year recert was being done properly? And what should be done because of what we know of materials and costs that the legislative process can change?
Well, I think, Glenna, that you have to understand that building officials in most cases are not structural engineers. And they do rely, as Mr. Slider said, on outside consultants and structural engineers that certify these buildings. But I think he raised an excellent point about why did it take so long. I think maybe some of the legislation has to be that you must initiate the commencement of the remediation efforts within X period of time of receiving the report, which takes it out of the hands of board members and the politics of, can we pass this assessment? Should we pass this assessment? It becomes, if you will, state mandated that it has to be done. I think it's a good idea at this point to have buildings checked, but remember that boards have fiduciary duties to do maintenance and do upkeep. Who knows in this particular instance, because nobody really should speculate, but obviously the engineer who did the report in 2018 said that the prior attempts to repair were ineffective. So the question becomes, were they just trying to put a Band-Aid on? Was that because they didn't want to spend the money? It's unknown at this point, and it's hard to say.
David Haber, let me go back without being redundant, but let me go back and dig a little bit deeper, ask you to dig deeper into this insurance issue, because I just simply have terrible misgivings that the people who lost their homes and who cannot go back to the remaining part of the Champlain Tower, that the insurance companies are going to fight them. I know that at least the insurance companies require that buildings be kept in, quote, reasonably safe condition. Do you think, in fact, the insurance companies, again, are going to say, well, we have demonstrable evidence this building was not kept in reasonably safe condition?
I believe that ultimately there will be claims against former board members for not moving quickly enough, maybe against, and I don't want to speculate, but unfortunately, Mr. Morbido for, not waving a larger red flag after the building wasn't starting the repairs early enough. There will be claims against the prior remediation company that apparently did ineffective repairs. And there will be officers and directors claims. The casualty insurance, there's going to be different groups of people seeking money. You're going to have the people who, unfortunately, tragically have lost family members. You're going to have people who have lost their homes. You're going to have people who may have been injured in the collapse. So you have different competing groups of people coming after a fixed pot of money, if you will.
Mm-hmm. Let me ask you an attorney question. Take us into the mind of some attorneys who are operating right now by filing lawsuits. Frankly, their public relations companies are sending us press releases on the lawsuits that these attorneys are filing as class action on behalf of the Champlain Towers residents. And all the while, we're reporting from the people who are working there on the scene that they're in full-on recovery, focused on the human toll at the moment, not even thinking about fixing a start, talking publicly about what might have happened there. Why are attorneys filing lawsuits, and with what evidence?
Well, let's just say there's a reason sometimes that personal injury lawyers have a lower trust rating than used
Well,
car
SI,
salesmen.
I didn't mean that to be a slam on any profession at all, just for the record. I wondered, really wondering, like, what is the basis for a lawsuit to be filed now?
Well, I've heard of one lawsuit filed in order to protect the documents. I'm sure, given the level of federal, state, county, and city investigation and oversight of this tragedy right now, no one is destroying documents, and I just don't understand. I think the focus needs to be on the recovery efforts, letting the engineers figure out what's going on with the building, why it happened, which will take time, and the grieving families, and not on filing lawsuits. There's no statute of limitations that's going to run between now and next year where lawyers have to jump in and file a lawsuit. I think it's inappropriate. I think it's sad, and quite frankly, I'm disappointed in my colleagues.
David Haber, we appreciate your candor and your expertise. Construction law expert David Haber, thank you so much for joining us.